please the Court. My name is John Perry. I represent the Agency for Workforce Innovation, and I would like to reserve 3 minutes of rebuttal time. Your Honor, I think that the legal issues presented in this case are fairly clear. The statutory language, and I'm quoting directly from Section 443.1715, (1) Florida statute, could hardly be clearer. Information revealing an employing unit's or individual's identity and any determination revealing that information is confidential and exempt from Section 119.07.1 and Section 24A of Article 1 of the state constitution. The issue in this case involves not...
Isn't that redundant to say, and any determination revealing the information?
I don't believe it's redundant, Your Honor. A determination is a specific document. When a person files a claim for benefits, there is an agency decision which announces the agency decisions and then gives the parties a clear point of entry into administrative proceedings. That is the determination. What is made...
Let me make sure that I understand what we're looking at here. We're looking at a request for notices of hearing that are issued after that determination is made. Is that correct?
That is correct, Your Honor.
Okay. So, and also the agency, as I understand it, oftentimes compiles data from employers about employees for purposes other than contested hearings on, or do they?
Yes, Your Honor.
So this is the kind of thing that the legislature wants to protect.
Yes, Your Honor.
We don't want that information going out. You can't go into the agency and get that information if you're a member of the public.
Yes, Your Honor.
Now, once the matter is put in contest for a hearing, where is that protected under the statute?
That is not specifically addressed in the statute.
Well, if it's not specifically addressed, can we incorporate it? But what I'm saying is, aren't we constrained to very narrowly construe these exceptions to public disclosure of information that the agencies hold?
Yes, Your Honor, and I think that construction has already been rendered by the 2005 Attorney General's opinion, which is cited in the brief. That Attorney General opinion draws a bright, clear line, and it is a line that I would submit to the Court is based not only on common sense but on the case law of Florida, that once the claimant and the employer come to the hearing and they present that information in a hearing that they know to be a public hearing, that amounts to what I would characterize as a constructive waiver of their confidentiality. But prior to that point, they have not made that waiver, even though they have, one side or the other, has made a request for hearing. Let me use this analogy. Let us say...
Okay, counsel, I'm still a little confused because all of this would follow the notice of the hearing. In other words, there would be a hearing, information be presented, or it may or may not, you could cancel the hearing. But what is it about the notice itself that is protected from disclosure?
Your Honor, there is nothing about the notice per se that is protected from disclosure. What is protected from disclosure is the identifying information in that notice, which the agency believes that it may not release unless and until the issue has essentially been rendered moot by the making public of that information by the parties.
Wouldn't the individual employee, once he seeks a hearing, wouldn't the waiver occur at that time?
No, Your Honor, I don't believe that it would, and the reason is...
And are there not cases when it is the employer who asks for the hearing?
Many cases, and it applies equally to claimant and employer identifying information, Your Honor. An employer or a claimant who asks for a hearing may at any point prior to the hearing withdraw that request. And the best analogy I can give to that is, let us say that I am a plaintiff in a slip and fall case, and I'm representing myself in that case. The defense attorney asks me to sign a waiver waiving my confidentiality rights. I write that attorney back saying, I would be happy to execute whatever waiver you send me. Please send me the waiver and I will execute that. The defense attorney takes that letter to the Agency for Workforce Innovation saying, hey, he's waiving his rights. Give us the information. I, on the other hand, change my mind and decide, no, I don't like that waiver, or no, I don't wish to waive my rights. But let us say that the agency, based on my letter saying that I intend to waive those rights, issues...
All right, if I understand where you're going, you're saying that these cases may be settled after notice issues before the hearing occurs.
Yes, Your Honor.
Do you have any information you can give us about how often that occurs?
I don't know how often that occurs, Your Honor. However, if it does occur once, it's a violation. And more importantly, for the court to grant Mr. Ritchie's relief, for the court to take Mr. Ritchie's position, it is going to have to implicitly or explicitly make a determination that prior to the actual release of the information, it's okay for the agency to produce that information based on the anticipated release of that information. And the problem with that, Your Honor, is that it makes it very difficult for the agency to know when it can and cannot release information. For instance, the outcome of this case may be in Mr. Ritchie's favor. If that's the case, fine. Every time we get a request that is like Mr. Ritchie's request, we will comply with it. But what if the person doesn't want the notice of hearing, he wants the request for hearing? Now, what is our...
Was that litigated in this case?
It was litigated, and the trial court made the distinction that the request for hearing would not be released because the request for hearing had information that was not contained on the notice of hearing. However, what if the attorney says, hey, you can redact all that information. All I want is the identifying information of the claimant employer. On what basis would the agency withhold that information under those circumstances based on the ruling that Mr. Ritchie is seeking from this court? And more importantly, what if the attorney who asked for this information doesn't ask for the notice of hearing or the request for hearing, but the determination, the announcement by the agency of its decision?
Well, that's expressly mentioned in the statute, right?
Well, Your Honor, so is claimant and employer identifying information. And what applies to one must necessarily apply to other. If there's an exception for information that identifies claimants and employers, there must also be an exemption for determinations. Or if there is one, I'm not aware of a legal basis for that distinction. And the agency would say, if a determination is asked for, hey, this person hasn't even requested a hearing. We don't even know if it's going to be made public. And the response that they would get and would be argued before the trial court and possibly an appellate court is, well, you don't know that it's going to go to hearing and be made public if there's a notice of hearing either. And there's a decision in the case of AWI versus Ritchie that says that that can be released. So the net result of this is going to be a situation where there is no legal basis to deny it at any time, because anytime a claim is filed, there's going to be a determination. And the clear statutory intent, the clear legislative intent, was to make this information confidential. And what we would have here, if Mr. Ritchie's position is adopted, is a judicial erosion of that language to the point as to make the statute almost a nullity. I see that I only have 54 seconds, so unless there are further questions, I'm going to reserve what time I have. Thank you, Your Honor.
Good morning. May it please the Court. I'm Mitchell Ritchie. I represent my law firm, Mitchell S. Ritchie, PA, in this appeal. I want to dispute one of the points that was made in the agency's argument. I've handled dozens of unemployment claims, and I've never been approached for a settlement. It's been my experience, once the notice of hearing goes out, you're locked into a hearing. And I wasn't expecting this matter to come up, but I believe it's the Bell South case says that even if an employer sends a letter to the agency and says it no longer contests the award of benefits, the agency must conduct a hearing to determine that there's a prima facie basis to award the benefits. So it's my opinion that when a notice of hearing goes out, there will be a public hearing. And I believe, just by our system of due process, we know that a notice of hearing is integral to a hearing, a true public hearing. The identifying information, therefore, is essential for that notice of hearing. I want to say, too, that there's no statutory...
Well, I guess you could have a notice. I mean, the one function of having public hearings is that the public can come in and see how it's all working. So I guess you could have a notice saying there will be unemployment compensation referee hearings on Thursday afternoon without identifying the litigants.
A general notice is really just no notice. You don't know the notice, you don't know the issues that will be involved, you don't even know the persons that are there. Situations could arise where this information is needed for witnesses, things of that sort, that they have no access to. It's just simply issued by the agency as a general notice.
As I understand, the purpose behind the confidentiality requirement is you don't want to discourage employees from exercising their rights.
Correct. And in this case, they've already exercised their rights. They've asked
before the notice of hearing issues.
That's correct. So I don't see this in any way implicating...
But now that's taking as a paradigm the situation where the employee is asking for the hearing. But
you're saying that if the employer asks for the hearing, it could be different?
I guess that's right. I guess either way, that once the whoever asks for a hearing, there's no making that public is no disincentive because you're headed for a hearing.
That's correct, for a public hearing. And using the waiver argument, once they ask for the hearing, they've waived their rights to confidentiality, to anonymity, as it turns out. I want to make the point, though, that there is no statutory authority limiting disclosure of identifying information to the public hearing itself. There is no. I don't see any in the statutes that are relevant to this case. And in addition, there's no regulatory rule by the agency restricting it to that point. The only rule that they've spoken, that they've adopted on that point is to say that hearings shall be open to the public. It says nothing about releasing information before the hearing.
Well, in fact, the rule itself talks about the hearing, but the statute really doesn't allow for disclosure of the hearing, does it?
I'm sorry?
The statute itself doesn't really exempt the hearing itself from public disclosure, does it? I mean,
No,
that's not an issue here, but I honestly don't see how the rule complies with the statute itself. Do you know?
The statute does not address that, Your Honor. I can only say that in looking at the statute, it seems that you have to keep in mind there are two classes of records here. One is the work records. That would be the payroll records, the tax records that are submitted on a regular basis. And then there are the appellate records that are put before the agency to settle the dispute regarding unemployment compensation benefits. I believe that the statutes that were adopted by the legislature address the former, the work records, which we acknowledge should be confidential, should not be released to the public.
All right, but if a stated legislative purpose was in order not to discourage workers from exercising their rights, how can you maintain that?
I'm sorry, Your Honor. The point I'm getting is how are they discouraged from exercising their rights if the appeal records are public, especially when it's the worker 9 times out of 10 who initiates the appeal. They're exercising their rights at that point. There's no disincentive.
I understand that argument, but I thought you were saying that the only purpose for the statutes was to protect the information routinely gathered from employers and perhaps employees.
Well, it was up until the 1994 amendments when the legislature included the specific appeal records of determinations. No other appeal records are included in that exemption from disclosure.
Maybe the legislature just wanted them to be confidential, not to be bothered by lawyers trying to solicit their business.
Well, Your Honor, you've raised that point, and maybe I should address that. Yes, it's true that I requested these records in order to offer my services to unemployment claimants. I could cite the law articles that show the statistics regarding the rate of success for people who are represented versus unrepresented claimants. 19% for unrepresented, 54% for represented. This court has commented on several occasions that the unemployment appeals process is largely pro se. This court has also pointed out on several occasions that the agency has not followed the law in certain ways, and that in that way attorney involvement in this area I believe would be beneficial to the administration of justice.
Now, do you concede opposing counsel's point that there's really no way to distinguish between the requests and the notices? In other words, that's also the request for the hearing, like the notice for hearing, comes after the determination, and under your rationale would also be subject to disclosure.
That was my argument in the trial court. The judge looked at the nature of both requests and decided that personal information could be contained in the request for the appeal, but the notice of appeal was simply it's just a boilerplate notice that's issued by the agency, and on that basis, she said that the notice of appeal would have no impact on the person's privacy and confidentiality concerns.
All right, but you did not cross appeal that. But
I did not.
But then, as Mr. Perry says, you might be able to go into court the next time, or to the agency the next time, and say that the rationale that would justify disclosing the notices would also require disclosure of the requests.
It is a possibility. Of course, this panel may give us guidance regarding that, such that another appeal or another case may not be necessary.
You might run into a res judicata matter on that if you're making the same request for the same agency, and you've got a trial court determination that wasn't appealed.
All right.
At least as far as you're concerned, but it may not affect some other.
Yeah. Well, depending on what the panel's decision is, the agency may adopt new rules regarding confidentiality. As I pointed out, they have no rules on this subject. So the federal law allows them to adopt rules, but they have not done so. If there are no further questions, I'll conclude my argument.
Thank you.
If it pleases the court, in the brief time I have remaining, I would like to address the last point first. The agency cannot adopt some substantive rules on confidentiality. Only the legislature can make information confidential and exempt from the Chapter 119. I'm not familiar with...
I thought, now, is there something in the statute that says that the hearings are public?
Yes, there is in our rule, Your Honor, and we could conceivably change that rule. And that would obviously change the complexion of this issue.
Judge Benton's question was about the statute itself. There's nothing in the statute that makes the hearing itself public, is there?
No, Your Honor. That is correct. Regarding the Bell South decision that Mr. Ritchie referred to, I'm not familiar with that, but I'd be willing to bet that decision did not involve a situation in which the individual who requested the hearing was making a withdrawal of the hearing. The practice of the agency, and I believe the rule is that whoever requests the hearing can withdraw the request for hearing. Regarding the issue of types of information that's confidential, no such distinction is drawn by the statute. It's information that identifies the claimant and employer. I see I've run over my time, so...
Well, I need to ask you, can the parties settle without a hearing, as he suggests?
Absolutely.
So there does not have to be a public hearing if the parties choose to settle.
They can choose to settle, or the party that requests the hearing can unilaterally withdraw his or her request.
So it's not the case that once that notice of hearing goes out, there's going to be a hearing no matter what?
That is not the case, yes, sir.
Okay.
Thank you.
Thank you very much, counsel. That concludes our cases this week. Court's adjourned.